I'm going to call the Associated Press versus Legislature matter first. Can we begin with appearances on the record, please?
Michelle Earl Hubbard on behalf of the plaintiffs.
Paul Lawrence for the defendants.
Mr. Brown for the defense, Mary Alexander.
Good morning, everyone. So we are here today for the court to give its ruling regarding the cross motions for summary judgment. I know that attorneys often take furious notes during this matter in anticipation of preparing an order reflecting the court's ruling on summary judgment. There will be no need to do that in this case because I have written an order and have made copies, which you will be given copies of at the conclusion of the court's ruling. Before I turn to the merits, I want to address briefly the objection of the legislature with respect to the filing of an amicus brief by the Attorney General in this case. While no relief has been requested from the court in connection with that objection, it's a very serious allegation to level against any attorney or office, and so the court will briefly address it. In no way, shape, or form is there a conflict of interest in this case with respect to the Attorney General filing the amicus brief in this matter. The rules of professional conduct relevant to this matter, 1.7, speaks in terms of conflicting representations of different clients. At the most simplest, on its face interpretation of that rule, the Attorney General in filing an amicus brief represents no client. So 1.7 under the rules of professional conduct simply does not apply. Even if it were to apply, however, the commentary to that rule, as well as Supreme Court and Court of Appeals authority, makes it eminently clear that the rules regarding conflicts of interest are different in the context of governmental entities and lawyers, given the competing constitutional, common law, and statutory obligations that those entities have. That is particularly true with respect to the Attorney General, which has broad authority and discretion to file amicus briefs and also has recognized statutory obligations regarding the interpretation of the Public Records Act. And more fundamentally, the court requested that the Attorney General file a brief. The Attorney General filed a brief. To do so is no more a conflict of interest than it would be for the Attorney General to issue an Attorney General opinion that happens to be adverse to the interests of some state entity. There is no conflict of interest whatsoever in this case, and the court will not address that matter further. Turning next to the merits of the summary judgment motion, sometimes judges give some reasoning and make everyone wait with bated breath for the ruling at the conclusion. That's not my practice. I'm going to be granting in part and denying in part both motions for summary judgment. As I indicated, I was likely to rule at the summary judgment hearing in this matter, and as the supplemental briefing has not swayed the court, and as the amicus brief by the Attorney General's office has confirmed, the individual defendants, i.e. the offices of the representatives and senators within the Washington State Legislature, are agencies under the Public Records Act and are subject to the disclosure requirements associated with that as a result. As I indicated at oral argument, the court was presuming that there would be at least one document associated with those obligations that was not turned over, and no party voiced any objection to that understanding. And as a result, the court finds that the individual defendants have violated the Public Records Act by failing to respond to the public records requests in this case as agencies under the Public Records Act. The court reaches the contrary conclusion as to the entity defendants, the legislature, the House, and the Senate in this case. Those entities' responsibilities under the Public Records Act are those defined with respect to the Chief Clerk of the House and the Secretary of the Senate under the Public Records Act. and as such, there is no violation of the Public Records Act as to those defendants. Now I will give my reasoning in part. I have written an order that is some number of pages long, and I will not repeat everything that is contained in that order, but there are some points I want to highlight for everyone's benefit. First, there are very important public policies that these issues present in this case. However, most of those policies are not for the court to concern itself with. It is the province of the legislature to determine what policies are the most important and how to effectuate those by passing legislation and implementing them into the law. There is one public policy, however, that is of the utmost importance in this case, and that is the one of the separation of powers. It is the legislature's role to pass laws. It is the court's role to interpret those laws. In so doing, courts presume that the legislature says what it means and means what it says, and courts will only go past the plain meaning and language of statutes where absolutely necessary. Simply because there might be some policy or raised eyebrow at a different interpretation of the law does not mean that the court should engage in Monday morning legislating and rewriting statutes that say something contrary to what the court believes it should say. With respect to the individual defendants in this case, the law, which is defined as the Public Records Act as a whole, and any related statutes, literally says that representatives and senators in their offices are agencies under the Public Records Act. The defendants have raised many different arguments contending that that is incorrect in this case. However, none of the arguments advanced by the defendants here can escape the fact that the plain and unambiguous language of the statute literally has a definitional chain that goes from agencies to state offices to state legislative offices. That is an inescapable syllogism in this case, that no authority has been referenced in this case that would allow the court to escape that. That is the law. That is what the legislature has said. If the legislature disagrees with that conclusion, the legislature has its own process to say something different in the law by amending the law. But unless and until the legislature exercises its authority to do so, that is its obligations under the Public Records Act. The court reaches, as I indicated before, the opposite conclusion as to the House, the Senate, and the legislature as a whole. The reason for that is that the court finds that the text of the Public Records Act, as it applies to those entities, is ambiguous. While the Public Records Act explicitly references, through its related statutes and definitions, the state legislative offices of individual legislators, it does not say anything with respect to the legislature or the House or the Senate. And thus we must construe the statute using the customary principles of statutory construction. That includes the requirement that any language in a statute must not be construed in such a way that would render portions of it meaningless or superfluous. While there is obviously in Public Records Act cases also an explicit canon of construction that requires the liberal construction of the Public Records Act, that rule of construction in those cases cannot lead a court to ignore other mandatory canons of statutory construction or to otherwise rewrite what is already written in the statute. Throughout the Public Records Act, the Act separately designates agencies and the chief clerk of the House and the secretary of the Senate. By separately designating those entities, it is clear that the legislature intended for the clerk and the secretary to not be deemed agencies under the Public Records Act. To interpret the Act any other way would render those portions of the Act superfluous. However, given that they are not agencies, it would make no sense for the House and the Senate and the legislature to be deemed agencies as well. Those two are inextricably linked as a corollary, because if the legislature and Senate and House were agencies, by necessity, its subordinate parts would also be agencies. And thus, working in reverse, the fact that the House clerk and the secretary of the Senate are separately designated in the statute means that those other entities are not agencies under the Public Records Act. That leaves the concern that the plaintiffs raised at oral argument in this matter about a quote-unquote black hole of records, and the concern that the legislature would move disfavored documents to these other portions of the legislature so that they would not be subject to public records requests. As an initial matter, the policy concerning those matters is not something for the court to determine. It is up to the legislature to determine which records should be subject to Public Records Act requests. However, even if the court were to consider that concern, the court believes that that concern is premature. Whether or not a document is a public record turns not on where it is physically located, but rather whether it was prepared, retained, used, or owned by an agency as defined under the Public Records Act. We have many cases where our appellate courts in Washington have recognized that public records may be in the possession of a third party. In fact, we have one of those cases here this morning, right after this case. And thus, it'll be for next steps in this litigation to determine specific records of disclosure obligations under the Public Records Act. Given that a specific record might not be in a specific specific office of a legislator or representative, if it were used or prepared or otherwise falling within the definition of a public record, it would be subject to disclosure in this case. And thus, the court does not see any concern about black holes of records in the legislature, given this differing definition of agencies as applied to that entity. But again, that is a matter that is not for the court to determine, that is for the legislature to determine. And if the legislature disagrees with this construction, it is welcome to use its own processes to amend the law to come to a different conclusion. Ordinarily, I ask at the conclusion of a ruling if the parties require any clarification because they will be preparing an order, but again, that is not going to be needing to occur here. I will allow the clerk to give each side 3 copies. There is the question, however, of next steps in this litigation. There will need to be an assessment of different records. I anticipate discovery is likely to be needed in this case. But other things may be sought in the interim, and so I will turn to the parties about how they would like to proceed next in this case. My initial proposal would be that we set a status conference at least 30 days from now so that we can contemplate what makes the most sense in this litigation and then come back together and have a discussion about managing this litigation. But I am open to suggestions from the parties, and whoever wants to speak first may do so.
Can I go, Your Honor? Do you mind if I do it from here, or would you like me to?
Not a problem.
Okay. So the one question, just in terms of the question and then in terms of next steps, there are 2 separate categories of record requests. One which went directly to, it says Dear Senator, Dear Representative. The other, again, went to every senator, every representative, was directed to the bodies. Based on what you just said about the definition of public record, am I correct in assuming that if the 4 individual defendants owned, used, retained, prepared records that were responsive to that other category when they themselves individually received the request, that is still a subject of this lawsuit? That would be the sexual harassment complaints.
And I will indicate that I am not at this juncture ruling that any particular request is or is not part of this lawsuit anymore. I recognize that issue, and that issue is not before the court on this motion and will be subject to continued litigation in this case. So I will entertain future motions and discussions. The court is not ruling that any particular request is or is not still part of this case at this time.
I understand.
Thank you.
Thank you, Your Honor. I think the status conference is a good idea. I do recognize, however, that given the first impression matter that we have and the mixed results for both sides, that it is likely that one or both sides will want to seek an appeal of this order. Granted, it is discretionary, but I think it is appropriate as a matter of law. And I guess if the 30-day status conference gives us a time window to file an appeal.
That's why I picked the 30 days.
Yes, I appreciate it. Then I think we're all on the same page as that is an appropriate step. But I would say that it's quite likely that an appeal would be filed in the interim.
So I would suggest February 23rd as a placeholder, and if action happened in the interim that would result in it making sense to not have a status conference at that time, I would entertain agreed motions to move that date.
I can tell you already that I am not in Washington State on the 23rd of February,
March 2nd,
or March 2nd.
March 9th.
I am in March 9th.
Mr. O'Hara?
I am looking, so March 9th, you said. Subject to some other judge saying I have to be somewhere, yes, that day would work fine.
Then let's set a status hearing on March 9th at 9 a.m. in this case. Is there anything else I can do for the parties this morning in this matter?
No, Your Honor.
And the clerk has the copies if you want.